I call this hearing to order. Welcome to the virtual hearing of the Senate Committee on Foreign Relations. Of course, I'd like to acknowledge the presence and participation of the Senate President, the Honorable Senator Vicente Soto, who therefore provides me with the quorum for today's hearing. So this morning, we will be taking up the following measures. Nine, an act and Senator Panfilo Ping Lacson. And there is also another one, Senate Bill number 2333, an act defining the maritime zones of the Republic of the Philippines, authored by Senator Ramon Revilla. For those who are, only for those who are ready, because there are two other measures not yet referred to the committee, but we're anticipating that they will be referred to the committee. SBN number 2459, an act to establish the maritime zones of the Philippines and define their legal regimes, harmonize Philippine laws with the United Nations Convention on the Law of the Seas and for other purposes, which I authored but only filed recently. And then another one, proposed Senate Resolution number 954, resolution condemning the continued presence and hostile acts committed by the Chinese maritime ships within our exclusive economic zone, as shown by the recent incident in the Ayungin Shoal, and urging the government to act and consistently assert our sovereign rights against China, authored by Senator Lacson. But definitely, these two measures, the last two measures which I mentioned, since I do not anticipate that they can be discussed thoroughly during this hearing, I will schedule another hearing for these two measures. Okay, so, so ladies and gentlemen, allow me to deliver an opening statement. In a coastal state like the Philippines, maritime management and security are of utmost importance, especially in the midst of threats from both state and non-state actors. Despite the magnitude of securing our coastline and all the waters within our sovereignty, including sustaining and protecting our rich marine life, the Philippines enacted its baselines law under Republic Act number 9522 only in 2009, 39 years after the United Nations Convention on the Law of the Sea was signed in 1982, or 27 years after the UNCLOS came into effect in 1994. As we know, the UNCLOS provides a constitution for the oceans that forms the framework and substance of the rules-based order of maritime governance. It encompasses the allocation of maritime zones to coastal states, including archipelagic states like the Philippines, whose status was formally recognized for the first time under international law. The next step is to establish the complete set of maritime zone regimes that the Philippines may define to attain its full geographical extent allowed under the convention. Hence, the need to harmonize our existing statutes with UNCLOS by enacting a comprehensive law to establish the maritime zones of the Philippines in accordance with the convention. This includes the express amendment of the inconsistent provisions of our prior statutes, which you will find under Chapter 7 of SB 2459, the bill which I filed. I find this very necessary in order to have a clear mandate for all our government agencies that will operationalize the same, such as our armed forces and civilian law enforcers who are represented today. So with that, I will first ask the committee secretary to recognize all the other invited resource persons, and then I will ask the Senate President and Senator Lacson if they have statements to make. So, Committee Secretary Sukandao, please, for the record, recognize our resource persons.
Thank you, Mr. Chair. Good morning, Your Honors. From the Department of Foreign Affairs, we have Deputy Assistant Secretary Emmanuel Fernandez and Ms. Micah Magnolia Fisher. From the Department of Justice, we have Senior State Counsel Freddy Ganchoon and Attorney Lourdes Gisela Mendoza. From the Department of National Defense, we have Director Jesse Pascasio. We have also invited the DOTR, but they have not submitted their representative. From the Armed Forces of the Philippines, we have Lieutenant Colonel Edwin Parcia. From the Philippine Coast Guard, we have Commodore Allen Dalangin, Lieutenant Rear Admiral Rolando Lizor Punzalan, Commodore Mitzi Silva Campo, Captain Neftali Castillo, Captain Ronald Pansipane, Commander Nomi Kayabyab, Lieutenant Maurice Reith Noronio, and Miss Irene Carandang. From the Philippine Navy, we have Captain Elizabeth Bacunawa Queda. From the National Coast Watch Council Secretariat, we have Attorney Melissa Loja and Mr. Jonathan Dirain. From the National Mapping and Resource Information Center Authority, we have Deputy Administrator Efren Carandang, Commander Antonio Valenzuela Jr., Commander Carter S. Lumaang, Commander Aaron Andrew Ching. And, Your Honor, we have Attorney Virgilio Calag from the Marina and Attorney Rochelle Raga, also from the Marina. From our list of experts, Your Honors, we have Ambassador Gilberto Asuque, who has recently retired, and we have Justice Antonio Carpio, Director Romel Manlawi from the Center for Intelligence and National Security Studies, and Professor J. Batongbacal of the UP College of Law. That's all for now, Your Honor. Thank you.
And we also have present my fellow senators, the Senate President, Senator Lacson, and I see Senator Tolentino. Did I miss any other senator, Comsec?
Senator Marcos logged in earlier, Your Honor.
Okay, we hope that she will be back to join us. So at this point, we can listen to the authors if they want to make some preliminary statements. Senate President, please.
Yes, thank you. Good morning. I would like to thank the Foreign Relations Chairperson, Senator Aquilino Coco Pimentel III, our former Senate President, for responding to our request that we called for a hearing to discuss Senate Bill 2289, or the Maritime Zones Act. I know that just like this representation, the chairperson truly understands the necessity of legislating our very own maritime zones in order to clearly map out what is rightfully ours and preserve and protect our maritime rights. This measure that I have proposed would greatly benefit our country, being one of the world's largest archipelagic nations. 70% of the municipalities in the Philippines are in the coastal area. Thus, our maritime environment is very important to our country's development. Filipinos living in these coastal areas highly depend on the huge deposits of mineral resources and marine life contained in these maritime zones. While these areas are considered a great blessing and big contributor to our economic growth, the fact that the Philippines is an archipelago can be considered, however, by some as a curse with respect to our country's security and sovereignty. Thus, the urgent need to enact our very own Maritime Zones Act. This proposed legislation has the following objectives, if I may, Mr. Chairman. One, to declare and define the maritime zones under the jurisdiction of the Philippines. Number two, to preclude any unwarranted and undesirable disputes with other nations involving our maritime areas. And three, to provide for the necessary flexibility in the passage of such subsequent laws pertinent to the rights and obligations to which the Philippines is entitled and may exercise over its maritime zones. So we are here to listen. Senator Ping Lacson is a co-author of the measure. We will listen to your invited resource persons, Mr. Chairperson, and what they have to say. I hope statements of support and inputs to further enhance the measure so that the aforementioned objectives will be achieved. I look forward to hearing more insights from our experts and learn from the discussions, since most of the provisions of the bill that I feel, which was co-authored by, as I said, Senator Lacson, are just reiteration of the United Nations Convention on the Law of the Sea, so the UNCLOS. I believe that it will not create any delays. So I hope that after today's hearing, the committee can immediately come up with their report and bring it to plenary. Thank you very much, Mr. Chairman.
Thank you, sir, Senate President Soto. If Senator Lacson has a statement to make, I'll give you the time, sir. Senator Lacson.
Yes, Mr. Chairman, thank you very much. Yeah, more often than not, when we only think of national security when we hear of China's encroachment into our territorial waters. It's actually much more than that. As the Senate President rightly mentioned, we're the second largest archipelago, comprising of more than 7,000 islands. And at least 50% of the Philippines municipalities and all major cities are coastal, with 62% of the population living in the coastal zone. Now, as a consequence, at least in 2017, yung harvest natin, dependence natin sa aquatic animals, nag-increase na ito sa 5.48 metric tons. An estimated 60% of the animal protein consumed by Filipinos comes actually from the sea. No, sa economic front naman, yung production ng yung fish production natin, nagbabalyo na siya ng 265 billion last 2018. On the other hand, 1.9 million fisher folk depended on fishing activities for their livelihood. So ganito yung mas malaking nawawala sa atin in terms of our economy. Not to mention yung energy resources, yung largest gas production, yung Malampaya, for example, 1.94 million standard cubic feet of gas and 75.04 million barrels of associated condensate. And then yung US Geological Survey in 2013 estimated a mean 2.5 billion barrels of oil and 25.5 trillion cubic feet of natural gas in undiscovered resources in the Spratlys Islands. Yung hydrocarbon reserves located in the Reed Bank is estimated at 55.1 trillion cubic feet of natural gas and 5.4 billion barrels of oil. So ito yung malaking effect not only on our national security, because obvious naman yun, but yung sa food security natin and our economic security greatly affected. So I think we really should listen to our resource persons to appreciate more kung ano yung importance ng West Philippine Sea issue sa bawat isang mamamayang Pilipino. Maraming salamat, Mr. Chairman.
Thank you, Senator Lacson. Senator Tolentino, if he wants to make a statement.
Thank you, Mr. Chairman. Just a point of inquiry, Mr. Chairman. I was looking at the previous measure I filed, I think a year ago, and it's Senate Bill 2288. 2289 is under consideration right now, but Mr. Chairman and my other colleagues, including the Senate President, 2288 is likewise germane and similar, and with all due respect should have been taken in consideration with all the other pending measures, and it has something to do with the redefinition of the Baseline Act of 2009 as well as the amendment of Republic Act 9522, bearing in mind the award given by the Permanent Court of Arbitration, in our case, the PCA case number 2013-19, because, Mr. Chairman, as I previously intimated last week, it would involve the inclusion as well as delineation of the maritime zones of islands and rock formations of the following, to name a few: Bajo de Masinloc, Sandy Cay, Allison Reef, and even Ayungin Shoal, Mr. Chairman. So I would move that the same measure should likewise be taken into consideration, because it would overlap and it would achieve the collective intent of the authors in the measures under consideration at the moment, specifically Senate Bill 2333, Senate Bill 2289, and the recent Senate Bill 2459. And this all involves the appropriate delineation of our maritime zone, Mr. Chairman. Just a manifestation that it should have been taken into consideration likewise in today's hearing. Salamat po, Mr. Chairman.
Thank you for that observation, Senator Tolentino. So at any rate, we will definitely hear Senate Bill 2289, the measure filed by Senator Tolentino. So it depends on the progress of today's hearing. But since I have also a bill just recently filed, so siguro I'll give the Senate President medyo advance notice that kung pwede January na po ito, mafile kasi baka hindi na kaya next week ito. Kasi we have to give our experts sufficient time to go over Senate Bill number 2459 and then also notify them to also study Senate Bill number 2288 of Senator Tolentino. Okay, and so but right now we will understand if our resource persons only focus their attention to Senate Bills numbers 2333 and 2289, because yun po yung notice that we sent to them. Okay, so we will now proceed with our hearing. In matters like this, I think we should first hear the DFA. Comsec, who is representing the DFA?
DFA, sir, is represented by Deputy Assistant Secretary Emmanuel Fernandez from the Maritime and Ocean Affairs Office.
Deputy Assistant Secretary Fernandez, if you're ready.
Yes, Senator Pimentel, thank you very much. And good morning, Your Honors. I am representing the DFA's Maritime and Ocean Affairs Office, and we prepared some general remarks on the subject bills. And with your permission, sir, I'd like to read those brief general remarks. It is a privilege for us to be invited to this public hearing to discuss the draft legislations defining the maritime zones of the Philippines. The enactment of this law would fully supplement our government's efforts to put the Philippines archipelagic house in order. It is a long-awaited sequel to the passage of Republic Act 9522, or the Philippine Archipelagic Baselines Law of 2009. With the archipelagic baselines in place, defining the Philippines' maritime zones would be an exercise of the right to establish such zones and prescribe their maximum allowable breadth under the UN Convention on the Law of the Sea, or UNCLOS, to which the Philippines is a state party. The Department of Foreign Affairs therefore lends its full support to this effort. The Philippines claiming such maritime entitlements and their extent within the allowable maximum breadth clearly establishes among user states the rights and duties of the Philippines as an archipelagic state, including the areas where the Philippines can exercise sovereignty, sovereign rights, and jurisdiction. The Department of Foreign Affairs believes that while the Philippines has existing laws defining some of its maritime zones, harmonizing them with UNCLOS and fully declaring the metes and bounds are necessary. Moreover, the bills serve as the foundation for the enactment of subsequent laws pertinent to the Philippines' rights and obligations over its maritime zones. They will also enable a more robust enforcement of Philippine laws and related international instruments on the protection of marine resources, the preservation of the marine environment, and the enhancement of maritime security and safety. In terms of its standing on various international issues, including issues vital to its national interests, harmonizing its domestic laws with the 1982 UNCLOS will send a strong signal that the Philippines practices what it preaches by adhering to the rule of law, international law, including UNCLOS. The department therefore welcomes the opportunity to work with the Senate to refine the contents of these bills. Thank you, Senator. Thank you, Your Honors.
So, maraming salamat mo, Mr. Fernandez. Next time na lang yung you can comment on the bills themselves, or you're not yet ready. Mr. Deputy Assistant Secretary Fernandez,
Yes, sir.
On the bills themselves, do you have any observation or?
On the two bills of Senator Soto and Senator Bong Revilla, we do have some comments, Your Honor. We noticed that they're similar to the House version that was passed on second reading last November 29. And therefore, for expediency purposes, since it is in the more advanced stage in terms of the House, it might be easier to actually focus on those two bills. But on the other hand, Senator, we, after a reading of your expanded bill, we also realized the great value of having a bill that encompasses not only maritime zones, but all other related maritime issues. And your proposed bill fully addresses all those other maritime issues. So we are actually open to considering both the versions of Senator Soto, Senator Revilla, and your expanded maritime zones bills. Thank you, Your Honor.
So thank you for that initial input. So sa technical working group na lang siguro yung nitty-gritty, no, on the actual wording or construction of the bills. Okay, Comsec, who's
Sir,
ready?
we have Senior State Counsel Freddy Ganchoon from the Department of Justice.
So Department of Justice, Senior State Counsel, Attorney Ganchoon, please.
Thank you, Mr. Chair, and good morning, Mr. Chair, and to the members of the Committee on Foreign Relations, as well as to the authors of the bill. Thank you so much for prioritizing this Maritime Zones bill. This is a very important bill. And good morning also to all colleagues in the executive branch, as well as the other attendees. For the Department of Justice, Mr. Chair, by the authority of our USEC for Legislative Affairs, as well as by the Chief State Counsel, I'm here to express the support of the Department of Justice for the passage of this bill, Mr. Chair. Under international law, well, the Philippines is a party to UNCLOS, and under international law, it is obliged to make necessary modifications in its legislation to ensure that these legislations are consistent with UNCLOS. We find, Mr. Chair, that in our existing laws, there are provisions that are not consistent with UNCLOS. For example, there's a statement in RA 3046 that says that we have a territorial sea as wide as several hundreds of kilometers around the archipelago. We also find that there are laws that need to be updated. For example, the definition of continental shelf, Mr. Chair, in Proclamation number 370, as well as certain provisions of Presidential Decree 1599 establishing or claiming our extended continental shelf. There are also provisions there that are not consistent with UNCLOS. So with the passage of a Maritime Zones bill, Mr. Chair, all of these laws that are not consistent with UNCLOS can be corrected, and some definitions or provisions therein can also be corrected in some of those other laws. And in addition, Mr. Chair, we haven't really claimed all of the maritime zones that we are entitled to under UNCLOS. For example, the contiguous zone, we have not yet claimed that particular zone. So with this Maritime Zones bill, we can already expressly claim our contiguous zone. And to note, Mr. Chair, that the bill of Senate President Soto, and this is also noted by Deputy Assistant Secretary Fernandez, it's actually similar to the substitute bill that was adopted by the Committee on Foreign Affairs by the House. And later on, when they edited it, it was adopted during the second reading last November 29. So the Department of Justice was part of that group. No? It attended the subcommittee hearings on the Maritime Zones bill at the House and gave its input already to that bill. So since the bill of the Senate President is similar actually to the substitute bill that was adopted by the House, we can support the bill of the Senate President, Mr. Chair, because with respect to the bill of Senator Revilla, we find that it's the old version of the bill. No, it has similar provisions to the old bills in the House, but those bills have already been superseded by the substitute bill as a result of the hearings conducted at the subcommittee level by the House Committee on Foreign Affairs. So, Mr. Chair, the Department of Justice fully supports the passage of the Maritime Zones Bill because it would correct existing provisions in our existing laws that are not consistent with UNCLOS, because we have this obligation under international law to make necessary modifications in our laws to make sure that they are aligned with UNCLOS, and at the same time we can expressly claim certain maritime zones that we have not yet expressly claimed, Mr. Chair. Thank you, Mr. Chair.
Thank you. Salamat po, Senior State Counsel Ganchon. Comsec, who's next?
Sir, we have
Hindi-
from the Armed Forces of the Philippines, Lieutenant Colonel Edwin Parcia of the Strategic Policy Division Office.
Wala siya sa list ko. Is he here?
Yes, sir, in the updated list that they gave us. Po.
Lieutenant
Lieutenant
General?
Colonel, sir. Lieutenant Colonel Edwin Parcia.
Okay, Lieutenant Colonel Parcia. Okay, I can see you now. Okay, so, sir, go ahead.
Yes, sir. Good morning, sir. I am Lieutenant Colonel Pasha, representing the Armed Forces of the Philippines, sir. Because our principal is attending some meetings, sir. With the position of the Armed Forces, sir, our lawyer, sir, will read our position, sir. Attorney Angeline Alvarez, sir.
Panyera, go ahead. Attorney Angeline.
Hello, sir. Good morning, sirs. Can you hear me po?
I can hear you. Okay, go ahead.
Yes, sir. Sir, first of all, sir, we thank you very much, sirs, for this very much welcome bill on maritime zones. This is very much helpful regarding as to how the AFP will conduct its maritime operations to ensure that the AFP would be able to more effectively may do its mandate of protecting the people and the territory. Regarding, sirs, for the specific provisions of the maritime zones regarding the bills, we will send, sir, our official comments regarding that matter. But so far, sir, we very much welcome these proposed maritime bills. Thank you very much, sirs.
So, thank you for that manifestation and for reminding the chair, to announce to everybody that you are all welcome to submit your position papers on the subject bills. Sama nyo na po yung kung pwede na pong the two measures that were officially in our agenda, the two other measures added just recently, plus the measure of Senator Tolentino, which he mentioned. So, thank you very much for that, the DND. So that's all for the DND. Sila lang, only the anong
Yes, sir.
branch ng Armed Forces 'yon? Nagsalita?
Strategic Policy Division yata, sir.
Okay, division pala. Okay. So, DOTR ang next.
Sir, they have not confirmed anyone to represent the DOTR. So we move to the Philippine Coast Guard.
Okay, Coast Guard. Di ba, ano naman yan? At Coast Guard is an
DOT.
attached, is the Coast Guard an attached agency of the DOTR or under sa DOTR?
Attached agency po, sir.
Attached agency. Sige. Go ahead, sir. Since we have Commodore Dalangin.
Yes, sir. Magandang umaga po, sir. Magandang umaga po sa lahat. I'm Commodore Dalangin. I am the Deputy Chief of Officer Staff for Intelligence CG2. And in behalf of the Philippine Coast Guard, we would like to express our support to these bills, being the primary maritime law enforcement agency that conducts regular patrols in WPS. Very important po talaga itong mga bills na to at malaking tulong po sa amin. Maraming salamat po.
So thank you for that expression of support, Commodore. Next would be what agency?
Sir, from the Maritime Industry Authority, we have two representatives, Attorney Rochelle Raga and Attorney Virgilio Calag.
Sandali, okay. So
Marina
Attorney
po.
Calag and Attorney
Rochelle Raga.
sige. Si Attorney Calag, I see him. Go ahead, sir.
Good morning, Mr. Chair. The Philippines has ratified the UN Convention on the Law of the Sea, the Law of the Sea Convention, and these maritime zones under a proposed Senate Bill 2333 and Senate Bill 2289, as defined or provided under the Law of the Sea Conventions, is a right granted to the states under international law. While it is already provided under the Law of the Sea Convention, and states have right maritime zones as provided therein, it would further strengthen our right under international law if we transform these provisions of these maritime zones into our national law. Hence, this authority, or the Maritime Industry Authority, fully supports the proposed enactment of this law for the Philippine Maritime Zones. Thank you, Mr. Chair.
Medyo masama yung sound ko, Attorney Calag. Basta you're saying that at least we are now transforming international law provisions into domestic law. Ganun po ba
Yes,
yun?
that's the main heart of my suggestion, that these proposed bills will transform the provisions of the Law of the Sea Convention, provisions of the Law of the Sea Conventions into our national law, and it would strengthen our right under international law. Hence, this authority fully supports the proposed enactment of this law. Thank you, Mr. Chair.
Thank you, sir. Thank you. That's on behalf of Marina. Okay. Comsec, sino pa?
Sir, from the Philippine Navy, sir, we have Captain Elizabeth Bacunawa Queda from the International Law and Special Studies Branch.
Sir, good
Captain
morning,
Queda.
sirs. Yes,
Okay,
sir, good
Panyero. Sino?
Captain Elizabeth Queda.
Elizabeth. Okay, Panyera. Go ahead.
Yes, sir. Good morning, sirs, honorable members of the committee. Yes, sir. Yes, sir. On behalf of the Philippine Navy, sir, we fully support the passage of this bill, particularly its intention to delineate the limitations and boundaries of our maritime zones. Of course, taking into consideration the arbitral award that we obtained with regard to our sovereign rights in the West Philippine Sea. Nonetheless, sir, we will submit our comprehensive and extensive position paper on this matter as we take a look more into this bill, sir. Thank you, sir.
Thank you. I anticipate the position paper will be discussing particular provisions. Ganun.
Yes, sir.
Sana ganun. Sana ganun. Apa.
Thank you, sir.
Next.
From the National Coast Watch Council Secretariat, sir, we have Mr. Jonathan Dirain.
Okay, Jonathan, go ahead.
I'm sorry, sir, but his internet connection is quite bad.
Okay,
Low
sige.
bandwidth
Next.
po siya. Then we move, sir, to the National Mapping and Resource Information Authority. We have Deputy Administrator Efren Karandang.
Okay.
Thank you, Mr. Chair. Magandang umaga po sa ating lahat. When the Philippines signed UNCLOS in 1982, we made a statement that, among other things, our signing of the convention shall not affect our sovereign rights arising from the 1898 Treaty of Paris and the 1930 US-UK Treaty, and that the concept of archaeologic waters is similar to that of internal waters. This statement was met with numerous objections from other states parties, such that in 1988, we made a statement before the UN General Assembly that the Philippine government intends to harmonize its domestic legislation with the provisions of the convention. 33 years after that statement before the assembly was made, the Philippines has yet to fully realize the harmonization of its domestic laws with the provisions of UNCLOS. While Republic Act 9522 was enacted to amend the archipelagic baselines to be fully compliant with UNCLOS, the other provisions of Republic Act 3046, providing for the treatment of waters within the baselines as internal waters, and the territorial seas extending up to the outer limits of the Treaty of Paris and US-UK Treaty are still part of our law. Yet, we are invoking the provisions of UNCLOS on the many instances that we are promoting and protecting our sovereignty and sovereign rights, notably during the South China Sea arbitration, when we made a submission and successfully defended our extended continental shelf in the Benham Rice, now the Philippine Rice region, and when we delimited our EEZ boundary with Indonesia. Likewise, our diplomats and other government officials have delivered numerous statements invoking UNCLOS while negotiating global and regional treaties. Mr. Chair, as the central mapping agency, NAMRIA needs a definitive legal basis to be able to draw the outer limits of our maritime zones. While we have RA 9522 providing for the treatment of Calayan Island Group and Bajo de Masinloc under the regime of islands, we still have to grapple with the existing provisions of RA 3046 on the territorial sea and internal waters for our main archipelago, and also the need for a clear basis to delineate the contiguous zone. We are grateful for the authors for recognizing the urgency of passing the Maritime Zones Bill in the light of pressing developments in our maritime fronts. We join our colleagues in the executive branch in supporting this vital piece of legislation. Thank you, Mr. Chair.
Thank you for that, Deputy Administrator Karandang. Medyo malalim ang research mo sa statement mo. So it opened my eyes to the fact that we can still cite in writing as existing in our statute books a law which provisions of law which are inconsistent now with the UNCLOS. Ganun ba 'yon?
Yes, Mr. Chairman.
These laws, these are for sure old laws na. So these have not been impliedly or expressly repealed by a subsequent domestic law. Walang ganon. From your research.
As far as I know, and our legal experts can perhaps correct me, not yet, Mr. Chair.
Oo nga, tama. Ganon din naman po yung briefing sa akin ng consultant ko eh. Ganon nga ang sitwasyon, no? So, malaking tulong yung pending bills to finally correct the situation and to fulfill our promise. Tama ba yun, sir? Deputy Admin? May promises pala tayo made in the UNGA.
Yes, Mr. Chair. When our late Senator Tolentino made that statement before, when we signed UNCLOS in 1982, it was
1982,
met by no less than 8 objections from other states parties, such that in 1988, we made a statement before the General Assembly that we will harmonize our domestic legislation with the provisions of the convention.
And then you mentioned that our diplomats and our negotiators have invoked numerous times UNCLOS. And we have actually observed UNCLOS in the delineation with the maritime boundary with Indonesia. Ganon. So,
Yes, Mr. Chair.
is the claim to Benham Rice also based on UNCLOS?
Yes, Mr. Chair. Article 70, fully compliant with Article 76 of UNCLOS.
So without UNCLOS, there is no Benham Rice to be talking about.
Yes, Mr. Chair. The sole basis of our submission to the UN is UNCLOS.
Okay, so mukhang klaro. Okay, who's next? Comsec.
Yes, sir. We have, sir, from our list of experts, we have Justice Antonio Carpio, followed by Ambassador Asuke, then Director Romel Manlawi, and Attorney J. Batongbacal.
Sige, is Justice Carpio with us? Andito ba si Justice Carpio?
Yes, sir. Opo.
I have not seen his anong tawag mo ba rito? His
I am
screen.
sorry, sir. Lumabas po ulit pala.
Oh, I do not see his name. I do not see his screen. Okay. Sige, si
Sir, we start with
Ambassador
Ambassador Asuke.
Ambassador Asuke, you have recently retired, sir. So congratulations, and we thank you for your service to our nation.
Thank you very much, Your Honor. Thank you, Senator Pimentel, to the members of the Foreign Relations Committee, as well as to all the senators participating in this virtual hearing on the Maritime Zones Act of the Philippines, as well as all former colleagues in the executive branch of government. Magandang umaga po sa inyo lahat. The Maritime Zones Act is now, more than ever, a necessary legislation. While UNCLOS is not mandatory, the convention nevertheless gives due regard for the sovereignty of all states to establish the legal order for the seas and oceans that will promote the peaceful uses of the seas and oceans. Allow me, Mr. Senator, to address the common sentiment of the previous speakers that we need to put in legislation the provisions of UNCLOS. I wish to provide a background on why we have to do this. The UNCLOS and its implementation in our national laws will be an exercise of that sovereign prerogative of the Philippines to establish and define the legal order in the West Philippine Sea and over our EEZ, continental shelf, the contiguous zone, the territorial sea, internal waters, archipelagic waters, the Philippine Rise, and the delimited EEZ in the southern Philippines with neighboring Indonesia, as mentioned earlier by Deputy Administrator Karangdang. This is the point in advocating with the Foundation for the National Interest and the Amador Research Services and other executive branches of the government for Congress, for our Congress to exercise its sovereign power to establish and define the legal order of our seas. UNCLOS provides the element or inputs for that legal order.
the draft Maritime Zones Act as submitted by Senate Speaker Soto and Senator Revilla, as well as the common text in the House of Representatives, will achieve this goal. I take note of the comment, Mr. Senator, that we already have our maritime zones because UNCLOS provides so, and the Philippines is a state party to this convention. My reaction to this comment is that the Philippines should not rely on assumptions that our maritime zones do not exceed the limits of UNCLOS. The Philippines is a dualist country where relations with the implementation of the treaties, Congress will have to pass the appropriate implementing laws and allocate the budget for the monitoring, securing, and management of the seas and its resources, guided by the Constitution, that the state shall protect the maritime, marine or the marine resources and wealth in its archipelagic waters, territorial seas, and exclusive economic zone, and reserve its use and enjoyment exclusively to the Filipino citizens. This was pointed out by Deputy Administrator Carandang, that there must be a specific legislation to assist the NAMRIA in delimiting the maritime zones as well as area sovereign rights of the Philippines. But to implement this, Mr. Senator, Congress will have to pass the bill because you have to send the NAMRIA people to the areas to establish the baselines of these areas that we claim. So the dualist approach to treaties is exercised in current laws on the environment, human rights, where universal application is called for by UN treaties. This law that is now pending in Congress, both in the Senate and in the House of Representatives, would lay the basis or the foundation for the future diplomatic negotiation to resolve the conflicting claims in the West Philippine Sea. We need this legislation in order to empower and define where our negotiators will start in resolving this issue in the West Philippine Sea. Senator, I thank the Senate Foreign Relations Committee for this invitation, and I hope that we can pave the way for the eventual passage into law of this proposed Maritime Zones Act. Thank you.
Thank you, Mr. Ambassador, for your inputs. The COMSEC was next.
So we have
Director.
Professor Romel Manlawi from the Center for Intelligence and National Security Studies and Philippine Institute for Peace, Violence, and Terrorism Research.
Yes, Professor Manlawi, thank you for joining us. You have the floor, please.
Thank you very much, Senator Pimentel. I'm truly honored to serve as your resource person to discuss Senate bills declaring and defining the maritime zones of the Philippines. I would like to commend three of our senators who have authored their own respective bills on the subject, Senator Ramon Bong Revilla Jr., Senator Vicente C. Soto III, and Senator Aquilino Coco Pimentel Jr. Your authorship of these bills are indications of your strong patriotic duty to defend our sovereignty and sovereign rights in our maritime zones. But as previously mentioned by the previous speaker, Ambassador Asuke, UNCLOS already provides the maritime zones of the Philippines. We just need to implement it through legislation. While these three bills, which I fully support, are complementary, if not identical, and indeed compliant with existing international laws, particularly the 1982 UN Convention of the Law of the Sea, I would like to raise, Your Honor, two major issues that our dear senators may want to examine for the eventual adoption of a law on Philippine maritime zones, because these issues have legal and geopolitical implications in advancing Philippine national interests in the West Philippine Sea. First, defining Philippine maritime zones in accordance with RA 9522 or the 2009 Philippine Archipelagic Baseline Law and the 2016 International Arbitral Award is problematic when applied in West Philippine Sea, specifically in the Kalayaan Island Group in the Sprat list. Why? Because RA 9522 describes the geographic features in the West Philippine Sea as regime of islands. However, the Arbitral Award declares that no feature in the South China Sea fits the criteria of an island that is entitled to maritime zones. Even Ito Aba, the largest island in the Sprat list presently occupied by Taiwan, is not an island based on the Arbitral Award, and that is why Taiwan is also opposing our arbitral victory. Thus, To make Philippine legislation on maritime zones consistent with the arbitral award, it is very imperative to amend RA 9522, and I'm very happy to hear Senator Tolentino presenting a bill towards this end. Okay, because provisions of RA 9522 as regards to the regime of islands is not consistent with our arbitral victory. It will be difficult for the Philippines to compel China to comply with the arbitral award if the Philippines cannot also comply. So we need to comply with the arbitral award. In relation to this, the arbitral award stresses that the Scarborough Shoal, though part of the exclusive economic zone of the Philippines, generates no entitlement on EEZ or continental shelf. And as part of Philippine territory, the Scarborough Shoal can only claim 12 nautical miles of territorial sea. So the technical working group should pay attention to these details. And based on the arbitral award, other features in the West Philippine Sea, like the Mischief Reef, Second Thomas Shoal, we call Ayungin Shoal, and Subi Reef, are low tide elevations that do not generate entitlement to maritime zones. The Philippines can only claim those features as part of Philippine maritime zones and not part of Philippine territories unless we challenge the arbitral award. Second, Your Honor, defining Philippine maritime zones in the KAG is also essential as we assert our territorial sovereignty there. The arbitral award has enormous implications for the status of all features inside the Kalayaan Island Group and maritime zones of these features. PD 1596, which declares Philippine sovereignty of the KIG, has no clarity on its maritime zones. Thus, we need to pass a law that will clarify the maritime zone of the KIG and define the status of the straight lines in PD 1596 to make it compliant with the arbitral award. In my humble analysis, Your Honor, while Philippine sovereignty over the islands and rocks within the arbitrary box of PD 1596 can still remain in force, its effects on maritime zone, however, are limited only to 12 nautical miles territorial seas around such features. Beyond nautical miles, maritime zones of the KAG will be defined not by PD 1596, but by the arbitral award, which is deemed to be implementing UNCLOS. Before I conclude, Your Honor, as we discuss hostilities in the West Philippine Sea as filed by Senator Lacson, let me stress 5 very important principles of UNCLOS that should inform our assertion of sovereignty, sovereign rights, and maritime jurisdiction in Philippine maritime zones. First, duty to cooperate. Cooperation is an obligation of all parties under UNCLOS because UNCLOS Article 74.3 states that all parties should undertake provisional arrangement of practical nature without prejudice to their existing claims. And second principle, Your Honor, is the principle of self-restraint. It is an act refraining from propagative unilateral activities that can jeopardize or hamper the reaching of the final agreement in order to promote cooperation in disputed areas. Number 3 is the principle of due regard. UNCLOS provisions prescribe due regard as an act to balance the rights, duties, and freedoms of other states when it exercises its own rights, duties, and freedoms in their maritime zones. In other words, if we conduct unilateral actions in our maritime zone, we have to also pay attention to the sensitivities of other parties using or with existing claims in that zone. And then fourth, the principle of without prejudice. It is a principle in UNCLOS that encourages cooperation among parties in conflict without detriment to their claim to sovereignty, sovereign rights, and jurisdictions in maritime zones. And finally, the principle of good faith. It is a principle in UNCLOS that encourages parties to cooperate and settle disputes with the right intention and good purpose in order to ensure appropriate behavior of all parties. And I sincerely hope that our maritime zone law will be informed by these 5 major principles. That's all, Your Honor. Thank you very much for the opportunity to share my thoughts on this activity. Thank you very much. Mabuhay.
Thank you, Professor. Comsec, who's next?
Sir, we have Attorney J. Batongbacal from the College.
Si Professor Batongbacal would be our last, no? Last
Sir,
resource person.
we still have po si Justice Carpio, but he keeps on We are always losing his connection po.
Sige, kasi because of I'm just informing my fellow senators that they can ask questions na siguro after the presentation of Attorney Batongbacal. Jay,
Yes.
go ahead, Jay.
Sir, naka-mute po kayo, Professor J.
Sorry. Good morning, Mr. Chair and honorable senators of the committee. Magandang umaga po. The Institute for Maritime Affairs and Law of the Sea has long been engaged in advocacy and cooperation with other agencies on matters concerning the law of the sea. And with respect to this particular bill, it is actually also, I think, part of a product of discussions with the other agencies as well. We have been very deeply involved in the technical committee discussions in both houses of Congress. And so we also support the statements already made by our colleagues, because we have been working with them for a long time as well, precisely to put into writing these important provisions. And we fully support the passage of the Maritime Zone Bill, actually, with urgency. We hope that it will be done with urgency, given the obvious need for us to really put our maritime house in order. It has been long in coming. We made that original commitment actually back in 1984 when the Batasang Pambansa ratified UNCLOS. And Senator Arturo Tolentino at the time, in his sponsorship speech for the concurrence in the ratification of UNCLOS, very clearly took the side that the Philippines will gain much more by abiding by UNCLOS, because it recognizes these extensive maritime zones which did not exist prior to 1982. These particularly refer to the exclusive economic zone and the extended continental shelf. And he very also clearly described the choice of the Philippines as either taking or pursuing a claim which will never be recognized by the international community. And in this, he was referring to the Treaty of Paris limits, the international treaty limits, or abiding by UNCLOS and basically making claims in accordance with international law, which the international community committed to recognize. And that is why for the government at the time, after serious study, they really recommended to the Batasang Pambansa the concurrence in the ratification of UNCLOS. So that was way back in 1984 when we ratified the convention. It is now more than 30 years. And this maritime zone bill is actually the most important step in fulfilling that commitment. For now, what we still have in our laws are provisions which basically gave us the foundation, that is RA 9522. But the problem is in all of this time, in all of this since the 1970s, we have actually avoided directly addressing the problems with our existing legislation, which provided loopholes or gaps, and created problems, for our government, in very clearly stating our claims, very clearly describing and establishing our jurisdiction. With respect to my colleague Romel's statements, I would just like to probably react because it is very important as well. And it's good that he raised these issues because these are among the most common issues being raised against the Maritime Zones Bill and the full implementation of UNCLOS. As to his first intervention with respect to the regime of islands not being consistent with the arbitration, actually it is unfortunately, that is not a correct understanding because the arbitration very clearly explained that when the term islands is used, even in law and in ordinary conversations, there are bound to be differences. So what the tribunal very specifically stated was that it is possible that maps of official maps or common names of features may be denominated as islands, but that does not necessarily determine their legal effect. And that's why Article 121, even though it is called a regime of islands, in those 3 paragraphs of Article 121, it specifically deals with the situation of both islands and rocks. Islands and rocks, as used in Article 121, are legal terms, not the ordinary geographic terms. So it is not actually correct to say that the arbitration and the regime of islands is not consistent. Actually, it is fully consistent. And in fact, it was the Philippines that made that argument in filing and pursuing the arbitration. As for the legal effects of the features like Scarborough Shoal, Mischief Reef, etc., precisely these legal effects were the ones advocated by the Philippines in pursuing the case. And therefore, the Maritime Zone Bill simply confirms that position, which was already pursued by the Philippines before the arbitration, which was then confirmed by the arbitral tribunal, and which is now recognized by the international community, except for China. Now, with respect to the second question that is raised by Rommel about defining the maritime zones, the issue of PD 5096 and any inconsistencies should be considered carefully, because number one, PD 5096, despite claiming a parallelogram as territorial, as an area of absolute sovereignty, that was amended subsequently by PD 5099, which then claimed exclusive economic zones extending from the baselines of the Philippines. And the baselines of the Philippines were comprised of both the baselines around the main archipelago of Luzon, Visayas, and Mindanao, and the baselines around each one of the features in the KIG. These baselines are normal baselines, because we did not say anything about establishing straight baselines around the KIG. The parallelogram created by PD 5096 are not baselines. So furthermore, after that PD 5099 caused that implied amendment, RA 9522 further clarified that the regime of islands, which essentially advocates the establishment of normal baselines again, reinforced the amendment of PD 1599 and therefore reduced the area of sovereignty in PD 1596 again. So either way that you look at it, PD 1596 was already impliedly amended. And so the maritime zone legislation merely reinforces and affirms that, and further provides for the next step of actually now clarifying and mapping the extent of these maritime zones around around the Calayan Island group. As for the principles that you mentioned, this is also true that all of these principles have been mentioned in UNCLOS, but we have to also keep in mind that it is on the assumption that all state parties are acting in accordance with UNCLOS, and these principles cannot be invoked to avoid compliance with UNCLOS or to give excuses for other countries to contest the proper implementation of UNCLOS. Good faith on our part essentially is about complying with our own commitment to fully implement UNCLOS. And that's why I think that the Maritime Zone Bill, in fact, is an indication of that good faith. Otherwise, what will happen is that we will be seen as a country that is having its cake and eating it too, meaning saying that we are and claiming that we abide by UNCLOS, and yet in our laws, we are not even taking steps to eliminate the pending inconsistencies in our laws, and that only creates more problems for us. So all of these 5 principles, while they are indeed applicable, we also need to consider that these principles must always be with the end in view of ensuring full and faithful compliance with UNCLOS. That is our commitment. As to how other countries may feel or react to this, that should really not be our concern, especially those countries that also ratified UNCLOS. Now, the burden is therefore on them now to prove their good faith, their cooperation, their self-restraint, their due regard, and their actions without prejudice. So the maritime zone legislation that we're undertaking actually shifts basically the burden of good faith, or the burden of demonstrating good faith and compliance with UNCLOS, not upon us, but on those other countries with whom we deal. It is true that this may create or continue certain problems and issues that we have, but at least we will be sure in stating our positions, because they are based on the correct interpretation and application of UNCLOS. We will be the ones at an advantage because we will always be on the moral high ground, which, as we've seen lately, the international community fully supports, even against the largest and strongest power in the region. So thank you very much, Your Honors, and good morning.
So thank you, Professor Jay. Thank you for that.
Mr. Chair,
Uh,
si Comsec po, we already have po si Justice Antonio Carpio.
Justice Carpio, if you're available, we are ready to hear your input, sir. Can you call him,
Yes, sir.
Comsec? Maybe si Professor Manlawi, meron ba kayong ron? Meron ba kayong parang comment sa comment ni Professor Batongbacal?
I agree with him, absolutely. Wala namang contradictory sa sinabi niya. Nagbigay lang siya ng mga caveats. Yeah, that those principles are not only applicable to the Philippines, but to all other parties. And I agree with him absolutely. And when it comes to legal matters pertaining to PD 1596 and the RA 9522 and the arbitral award, I leave the legal technicalities to the lawyers because I am legal science scholars. Thank you very much. I agree with him.
Thank you.
Thank you.
And thank you. To clarify lang, parang to get our facts straight, Professor J, in the Kalayaan Island Group, the tribunal indeed recognized that there are islands there, although not generating EEZ, but generating territorial sea. Ganun po ba yun?
Yeah, 12
Jay,
nautical.
nakamute ka, Jay. Professor Batongbacal.
Yes, Your Honor, that is correct. No, so that very clearly demonstrates also that we should distinguish between the legal effect and the use of legal terms and the common taos use of the term. So even though it's an island, the legal effect is the same as a rock, but that does not change in any manner the legal effects.
So the maritime zone there is a territorial sea. Ano po ba yan?
Yes, Your Honor.
Only? How about the contiguous zone?
The contiguous zone is actually ancillary to the territorial sea. So it can also have a contiguous zone if the state declares it around it.
Automatic yun, even if the island cannot sustain economic life on its own.
Yes, Your Honor, because the contiguous zone is like a buffer zone that provides additional protection or an additional area so that you can ensure that your territorial sea is adequately enforced.
Even if there are no inhabitants on the island.
Yes, Your Honor, because it's possible, for example, that an incursion into the territorial sea would be for the purpose of, say, smuggling goods or people, no? Which happened before, actually, in 1963, when Scarborough Shoal was used as a smuggler's base by unknown individuals. The Navy went ahead and destroyed the smuggler's base there.
But the arbitral ruling did not name the owner of the islands.
Yes, Your Honor, because naming the owner would be a determination of sovereignty, and that is outside its jurisdiction. They also clarified that even in the award on jurisdiction and admissibility, that they would stay away from that particular question.
Okay, but we are just being consistent because our position is we own those islands as territory.
Yes, Your Honor. We have always been exercising sovereignty over that area, and China never appeared on the scene until 1994.
Thank you for those factual observations, Professor Batongbacal. So if Justice Carpio still cannot get online, I can ask my fellow senators if they have questions or reactions, sir.
Yes, thank you, Mr. Chairman. I'll give way to Senator Lacson. I think there are very important issues she would like to bring out.
Thank you.
Yes.
Senator Lacson.
Yes, Mr. Chairman, thank you. First, I'd like to manifest that we should invite in the next hearing the Westcom commander, Vice Admiral Enriquez. We checked with him, and he told us that he was not sent an invitation to attend, but he is willing to attend because after all, if the bills under consideration will be enacted into law, they're the ones who will enforce. Sila po yung law enforcement dito, Westcom, Philippine Coast Guard. So it is also important that Admiral Laroya is also in attendance. Next, I would also like to manifest other personalities, so we will have a first-hand view of what problems are being incurred by the people in the area. For example, the Jember, the ship captain, we should look for him and invite him to share with us their actual experience when their vessel was rammed way back in 2019. I think this was in June 2019. Also, the issue of the water cannon incident, and I think Admiral Enriquez will be can share with us, what actually happened during the resupply of logistics in the Ayungin Shoal. So with that, I'd like to ask Professor Manlawi if we are already in the question and answer part, Mr. Chairman.
Yes, sir. Yes, sir. We
Yes.
are.
Yeah, I listened to his presentation, and he mentioned the 5 principles. Now, I'd like to ask Professor Manlawi, how many among the 5 principles that he mentioned are being violated by China, in their recent activities in the West Philippine Sea? Of course, we're not limited to the ramming of the Jember vessel and, of course, the water cannon incident in the Ayungin Shoal last November 16. So how many more are being violated by China in this regard? Because these are very important matters, Professor Manlawi. We only would like to be educated in this regard.
The unilateral activities of China in the West Philippine Sea are in fact not consistent with these 5 principles, because they were conducting military and paramilitary activities that hamper cooperation, okay, and without due regard to our national positions, and of course, ramming our ship or water cannoning our vessels are not done in good intention. It's really, was done in a bad light. That is why I am reminding all parties in the West Philippine Sea to really uphold these 5 major principles if they want peace and cooperation to really prevail in the South China Sea. Because if only the Philippines will uphold these 5 principles, peace and friendship in the South China Sea will not really happen. So all parties, especially all parties to the UNCLOS, should adhere to these 5 principles and comply with these 5 principles. That's why Philippines and China need to go back to the negotiating table to be reminded of these 5 principles that both parties vow to uphold.
Thank you for that, Professor. Has the Philippines ever violated any of those principles?
In fact, we are so sensitive. When we decided to leave Ayungin Shoal during our resupply mission on November 16, we implemented the principle of due regard. We did not retaliate. And then we pursued all diplomatic channels. We also exercised self-restraint because we did not use our military assets to defend our vessels there. And we also reminded China about our good intention to remain friendly with China, despite the incident in the Ayungin Shoal. I think the Philippines has been consistent in upholding 5 major principles, and that is why we have to maintain this kind of actions, because we are in fact not only promoting good behavior in the South China Sea, but we are also encouraging other parties to maintain that good behavior. So we exercise self-restraint, we are implementing preventive diplomacy, we are engaged in a lot of confidence building. We are so kind to all parties, and I hope that other parties will also reciprocate our kindness. Napakabait po natin, Senator. Umiiwas po tayo sa gulo lagi. Kaya we have the support of the international community, we have the support of ASEAN, and even among scholars, they have their support of me also, because alam nila na we are so humble in our position there, but we want to maintain our moral high ground in this issue, because we are also telling to China that that good behavior should also be compelled not only to small and middle-sized powers, but also to major powers. In fact, China has the greater obligation to show to the whole world that compliance with UNCLOS requires the advancement of these 5 major principles. Otherwise, if China cannot comply with these 5 major principles, China cannot lead parties in the South China Sea to make the South China Sea a sea of peace, friendship, and prosperity for all. Kaya nga dapat mag-comply din yung China dyan. And it takes a diplomatic skill to really encourage China to be truthful to what it says. Okay, so that's all, Senator. Thank you very much for your questions.
Thank you, Professor. I could not agree more. No? I assume that you read the full text of my resolution, Senate Resolution 954. And in your view, is there an attempt, in that resolution, is there even an attempt on the part of the Senate, or at least this humble representation, to violate any of the 5 principles that you mentioned?
No, it's very nuanced, Senator. In fact, the spirit of that resolution is in fact consistent with the principles of UNCLOS, especially the principle of exercise of self-restraint and due regard. But we also have to uphold another principle that all parties must also exercise duty to comply with those principles. Thank you.
Any of the resource persons can respond to this next question, Mr. Chairman. Among the current country claimants in the West Philippine Sea, how many of them have adopted their own maritime zone laws? Mr. Chairman, anybody can answer? Professor Batongbacal, would you know how many among the claimants, the claimant countries in the WPS, West Philippine Sea, have already adopted their own maritime zone laws?
Yes, Your Honor. Thank you for the question. China, Vietnam, Malaysia have adopted various maritime zone laws, but they have remained ambiguous with respect to the islands in the Spratly region, no? Including the Calayan Island Group. That is, they have not drawn specifically the maritime zones around each one of these islands, no? But in terms of their statements and positions, Vietnam, Malaysia, and implicitly Brunei have all adopted the position that none of these islands generate easier continental shelf. And in fact, Vietnam issued a formal statement in support of the Philippines. During the arbitration proceedings, they sent an intervention, well, not an intervention, but a statement also taking the position of the Philippines that none of these islands generate an continental shelf and exclusive economic zone. So I think that most of these, well, all of the countries have been rather cautious with respect to publishing the final maritime zones of each one of these islands. And it was only recently, actually, especially during the advent of the arbitration proceedings, that they finally settled on not claiming any continental shelf or exclusive economic zone around these various islands in the South China Sea.
Thank you, Professor. Alam nyo, grabe yung memory bank ninyo pagdating sa maritime law, no? Pati yung historical background and all. And I take my hat off. Ano? It's not because you're present, but it's really a sentiment that I'd like to share with my colleagues. So I would always love listening to you. As a matter of fact, whenever you are being interviewed, ano? Because it's very informative. Ano? Natututo po kami. So we have no disagreement pagdating sa passage ng ating sariling maritime zone law, because ito yung mag-a-arm sa ating law enforcement agencies like the Coast Guard and as mentioned, pati NAMRIA, ano, para ma-establish nila talaga yung boundaries, ano, limits and bounds. So aside from that, ano po ba tulong pa ang magagawa nitong measure if ever it is passed into law para ma-enhance yung ating not only our claims, ano, but our rights over the West Philippine Sea, at least yung talagang nasa ating teritoryo?
Yes, Your Honor. Well, actually, this maritime zone bill is very important because essentially it, kumbaga, it renovates the foundation of the country's maritime jurisdiction, no? And clarifies the full extent of the powers that we will be willing to exercise within the seas around us, no? As well as in our inter-island waters. So in a way, everything will flow from that, no? But this, as you said, is still is just the foundation. It's the starting point. The next step, of course, will be providing our different agencies with, number one, the wherewithal, no, to be able to implement certain aspects of this, such as final mapping and charting of the zones, the final determination of baselines around each feature. Second would be providing the armed forces, Coast Guard, PNP Maritime Group, with the appropriate budgets to enable them to build the corresponding capacity for each particular area under their care, no? Because of course not everyone can go all the way out to the 200-mile EEZ because we have limited funds available. We have to rationalize it. So by providing this clearer delineation of the various areas that they need to protect and patrol, they can then come up with much more precise budgetary allocations and better plans for conducting their activities in the zones. Also, our own foreign affairs will be benefited from this because they can also now fully implement various other obligations related to the maritime sphere. So like our environmental obligations under many IMO conventions, no? And even the Convention on Biological Diversity, all of those other international agreements to which we are party, which need to be implemented at sea, will require, of course, this basic legislation, and DFA will also require some of those resources, no, to be able to properly make representations in the different international fora, no, that we have. And it will also provide DFA with the clear basis now to also undertake negotiations with our neighbors, because not all zones will be finally delimited unless we actually come to boundary agreements with them. So like we have an EEZ boundary with Indonesia, but we do not have a continental shelf boundary with them yet, no? So all of these different negotiation activities can also now take place with a full knowledge now, with a much better starting point for them, because there is no longer any ambiguity. So these are just some of them that already comes to mind, Your Honor.
Thank you. Among the issues that you mentioned, I think one of the most important, if not the most important, is appropriations. You know? Because there's no law. Congress will just appropriate something to the agencies that are supposed to enforce. That will not directly affect yung sa West Philippine Sea, yung sa enforcement natin. One final question, Mr. Chairman. China has always invoked historical rights. You know? And I'd like to know how much legal basis or credibility does historic rights carry pagdating sa international law? Professor?
Yes, Your Honor. That was actually directly ruled upon by the tribunal in the South China Sea arbitration. China's claim to historic rights within the South China Sea, including the West Philippine Sea. And the tribunal very clearly stated that insofar as its apparent claims into the West Philippine Sea, which was characterized as a claim to the natural resources therein, no? Because even China has not clarified exactly what it is that they're claiming and exactly what are these historic rights that they're basing them on. So the tribunal had to do it for them. The tribunal very clearly stated that China does not have any valid historic claims to the area of the West Philippine Sea. And if at all they will have any valid historic claims, it can only now be pursued in accordance with the parameters in UNCLOS, which means they can only claim EEZ and continental shelf. And since none of the islands here that they also claim have those EEZ continental shelf, the only possible overlap between a Chinese EEZ and continental shelf and a Philippine EEZ and continental shelf is far up north, near Batanes and Ilocos Norte, but certainly not going as far down as Scarborough or the Calayan Island group. The only legitimately disputed areas that we have with them now are basically the sovereignty over these islands and rocks and their associated territorial sea. But that is very little. That probably only comprises about 5% perhaps of the entire area of the West Philippine Sea when you reckon with the continental shelf and exclusive economic zone. That is the whole reason why from the beginning, the Philippines moved towards that position of minimizing the effect of these islands because they realized that the more valuable real estate, so to speak, is the 200-mile EEZ and continental shelf. And that is why it was a major victory for us. And that's also why China is so mad and refuses to acknowledge it because they essentially lose any claim to this entire area of our 200-mile EEZ and continental shelf. So baliwala po talaga yon, no? Because even China could not present evidence, clear evidence of continuous usage of this area since ancient times, which is the essence of historic right, no? How can they claim continuous usage of petroleum resources 6 kilometers below the sea surface, no? So that's impossible. And very clearly as well, the tribunal said that if at all China made any of these claims, it appears to have been made really officially only as of 2009. So it's a fairly recent claim because before that, they never clarified it. No, they never clearly said what exactly were they claiming. Was it just the islands? Was it the maritime zone? Was it an easier continental shelf? Nothing. No answer. No clear answer from China. So that's why they cannot possibly have any historic rights claim to the West Philippine Sea.
Thank you, Professor. Bakit po kaya walang enforcement component yung arbitral ruling? Ano? Kindly enhance my education in this regard.
Well, kasi po the judgment is what we call a declaratory judgment, no? It very clearly states what the proper application and interpretation of UNCLOS, no, and essentially who is right and who is wrong between the two contending parties, no, who are making these claims. No? The equivalent in Philippine domestic law is a declaratory relief, a judgment of declaratory relief, where the trial court may be called upon to interpret the terms of a contract for the parties, no, if they have a dispute. And based on the judgment of the court, they will then have to adjust their respective positions and actions and relationship based on what the court interpreted that contract to mean. So that is essentially what the tribunal also did. And that means that enforcement of the judgment actually remains with the parties themselves. They will enforce it simply by acting in accordance with the interpretation of the tribunal. And the Philippines, despite claims that of many people saying that there is no third party that will enforce the judgment, actually, the Philippines does not need the third party. All it needs to do is exercise its rights in accordance with UNCLOS, and that is the position that will be complied with by other countries. That is the position that will be supported and reinforced by other countries. That's why, if you notice, after the arbitration, the other countries have now been more vocal when we state our position with respect to what happens in the West Philippine Sea. Because it is clear now to them that the Philippines has rights within its EEZ and continental shelf. And it is also clear to them that China is acting contrary to UNCLOS and contrary to Philippine laws and regulations, which China is obligated to comply with under UNCLOS. So that is how we enforce it. No, we do not need a third party. All we need to do is go ahead, exercise our rights, whether it's fishing, patrolling, offering for petroleum concessions. We go ahead because if China interferes with that, if China takes action against that, then it will be very clear who does not have any justifiable reason to take such action. And the international community will be bound to support us because the tribunal already laid down clearly who has the legal rights in this area.
What other course of action that we can take under these circumstances is to appeal to the international community to exert whatever political pressure they can have on China to comply with the ruling. It cannot be solved by war, no? Of course, especially in this day and age of modern technological warfare, nobody wins. So I think we should take a more proactive position to appeal to the international community to help us exert pressure on China in this regard. Would you agree, Professor?
I fully agree, Your Honor. In fact, there have been some discussions as well, especially among the technical agencies, on steps that could be taken about that. This particularly opened up after March 2019, when the Chinese clam digging operations on Scarborough Shoal were recorded on video, and it came out in the news. There were already that initiated very serious discussions among the different agencies on various steps that can be taken to take advantage of whatever available means is in the international community or in international forums. No? And actually, our own institute suggested that around, I think, 11 different ways by which the Philippines can take certain legal actions, no? Not necessarily court action, but representations before many different international organizations and bodies, which can mobilize international pressure against China to make it accountable for its damaging actions in the Scarborough Shoal. And since that time, there have been additional discussions among the technical agencies, and they are actually preparing for it and providing a considerable budget for some of these activities. No? So hopefully, if the position of the Philippines, no, is now really clarified through this legislation, and subsequent executive administrations will also take a consistent and strong position in favor of the rule of law, those many different avenues can be pursued, no? And I think that will help us defend our interests in the West Philippine Sea, even if China continues to persist in its activities, in its unilateral activities. We have to face it in a way. This is a test of will, no, between the different countries, and our political will can be best expressed by our governments and our agencies' different activities, no, to protect our interests in whatever way they can, whether it is directly at sea or through through multilateral forums in the international community.
Thank you, Professor Jay, for the very instructive responses. Thank you, Mr. Chairman. That's all for now from this representation.
Thank you. Thank you very much. But Jay, I noticed you made the statement that the tribunal precisely does not have an enforcement mechanism because it leaves it up to the parties involved to try
Yes,
to
yes.
solve the problem. So, meaning to say, from the point of view of international tribunals or international law, the parties involved in a dispute really have no choice but also to continue communicating with each other. Yun ba yun?
Yes, Your
Mag-usap pa
Honor.
rin na mag-usap? Ganun ba
Yes,
yan?
Your Honor. Mag-usap talaga, but this time, the ambiguity that existed before, a large part of it has been eliminated. That really is the way with international tribunal decisions. There is no third party that enforces the decisions of international tribunal, even of the ICJ. What it results in really is an opportunity and a basis for the parties to the litigation to then change their position and their posture, and then negotiate on a more equitable basis, so to speak, no, based on what was ruled upon by the tribunal.
So, di ba meron, there is a popular case, yung US-Nicaragua case where the US lost. Ito ba yung placing of ano ba yun? Ano ba tawag mo doon? Sa mines, mines at the harbor or coast of Nicaragua.
Yes,
Oh,
and also funding the insurgency in Nicaragua against the communist regime in Nicaragua. So
so
these are
Nicaragua
paramilitary
won.
activities. No?
Nicaragua won. US lost. So was this ever implemented through by the ano tawag mo doon? By the parties themselves talking to each other?
Yes, Your Honor. Essentially, the substance of the decision was implemented because the purpose of the case was to get compensation from the United States for its activities against Nicaragua. Now, the US refused to implement the decision. That's true. But then after some, I think it was around 20 years, with the change in administrations on both sides, eventually the U.S. negotiated with Nicaragua to pay the equivalent compensation, but denominated as development aid. So Nicaragua got what it wanted, which was essentially the compensation. And in exchange for that, they agreed to no longer pursue the annual resolutions that they were sponsoring in the United Nations, calling out the U.S. for to comply with the decision. No? So yes, the U.S. had to adjust essentially, no, its position as well, and become more accommodating of Nicaragua's demands. No, because by after about 5-10 years, the U.S. realized it was more trouble than it was worth. No, to continue resisting the demands of Nicaragua. So they found a way to address the demand without giving up technically their position.
So thank you for that. So ganun pala 'yon sa international level, no? So instead of filing a document stating that there is already satisfaction of judgment before the tribunal, just the satisfied party just did not pursue anymore the parang an action, which was the filing of a resolution asking for the enforcement of the decision. So parang ganun ang nangyari.
Yes,
Okay.
Your Honor. Basta na-satisfy na sila, then
Basta
that's it.
na-satisfy na. Okay. So thank you for that. Anything else? My fellow,
Chair,
my colleagues. Is Justice Carpio ready?
sir, we can call him again, sir. And Attorney Ganchon of DOJ and
Sige. Sige.
is also raising her hand po.
Sige. Please participate. Sige. Then si Ambassador. Si Attorney Ganchon muna. And then, yes. Go ahead, ma'am.
Thank you, Mr. Chair. Actually, I raised my hand while respect to historic rights, Mr. Chair, historic rights would refer to exceptional rights in international law, and these are rights that would not normally arise under the general rules of international law, except upon the operation of a historical process. So may requisites for the existence of historic rights. For example, I have consistently exercised this right to the exclusion of other states, and the other states have acquiesced to this right. So yun po yung requisites of existence of historic rights. In the case of China, Mr. Chair, and as stated by Professor Batongbacal, this has been directly addressed already in the Arbitral Award, when the Arbitral Award said that what China exercised actually in the South China Sea is not historic right, but the freedom of the high seas. Because before the 1982 UNCLOS has established the exclusive economic zone, what are the waters beyond 12 nautical miles? The waters beyond 12 nautical miles, Mr. Chair, are the high seas. And in the high seas, everybody can fish, everybody can navigate. So this claim of China that historically for thousands of years it has been navigating or fishing in the area has given rise to a historic right in its favor that it now owns all the natural resources inside the nine-dash line is wrong, because what it was exercising before, Mr. Chair, is just the freedom of the high seas. If you're merely exercising the freedom of the high seas, this cannot give right in your favor of exclusive rights. And if China has failed, no, the tribunal has not found any evidence that throughout the centuries China has regulated fishing or navigation in the South China Sea. So wala po talagang basis yung historic rights, because the navigation and fishing of China there is merely an exercise of the freedom of navigation, the freedom of the high seas, which is also available to the other states. The Philippines would also. And to Senator Lacson's question, when it was superseded. But actually, what the tribunal also said, that what was superseded is not actually historic rights, but the freedom of the high seas, because that area has now become the exclusive economic zone of the Philippines. So na-supersede po yung claim niya. Yung claim niya is not actually based on historic rights, but on the freedom of the high seas. But the freedom of the high seas no longer applies in that area because that area has now become the exclusive economic zone of the Philippines. So that's what I would like to add during the question on historic rights, Mr. Chair. But on the enforcement, Mr. Chair, I'm just thinking when you're asking about enforcement, Mr. Chair, and why is it that in the international plane, there is no world police? Well, the international legal system is totally different from the national legal system, Mr. Chair. In the international legal system, there is no world court with compulsory jurisdiction. There's no world police. There's no world legislature. The General Assembly, even if it issues a resolution that is unanimous, is not legally binding. So magkaiba po talaga yung international legal system from the national legal system. In fact, and the reason for that, Mr. Chair, is that who are the members of the international legal system or the international community? It's because the members thereof are states who are sovereign equals. So nobody can be higher than those states. Nobody can be a world police that is higher than those states. Kaya po walang world court na may compulsory jurisdiction. The ICJ has no compulsory jurisdiction. So the issue enforcement, so who would enforce the award or the decision if all members of the international community are sovereign equals and nobody is higher than them? Who would enforce if all subjects of international law are sovereign equals? It would be the states themselves also, Mr. Chair. Kasi sinasabi ni Professor Day, depende rin sa states na if they would comply. But based on explanation by international law writers, most states actually comply with their obligations in international law. There's a study made that most of them would comply. It's just that instances of non-compliance would become headline. So feeling mo maraming hindi nagko-comply because when they don't comply, it becomes a headline. But most states actually comply with their obligations. That is because they have that obligation in international law that any treaty that they become a party to, any treaty that they enter into pursuant of pacta sunt servanda, they should comply with their obligations under the treaty. So based po ito lahat, no, the working of the international legal system is based on the cooperation of the states themselves, such that if one of them is not complying with international law, the others should talk to that member of the international community for that member to comply with international law because it's in the interest of each state that the international legal system is a stable system, Mr. Chair. So kaya the Philippines would need to engage not just in bilateral approaches, but also in multilateral approaches so that it has been given this award so that this award can be also enforced, no? But yung enforcement po kasi, Mr. Chair, no, sometimes people think that once you get the award, that is the end of it. It's not the end of it. No? As Professor Jay has explained, the purpose sometimes of an award, in case the other party does not comply, is to clarify certain issues. Once the issues have been clarified, then you can talk to the other state and to the other states to share your values in upholding the rule of law. Para po, even if the award is not 100% enforced, at least you can get the outcome that is based on the award. For example, the US does not recognize the decision of the ICJ in Nicaragua versus US. But the end of it all, the outcome has been achieved anyway, even if the US did not recognize the decision because the outcome that Nicaragua wants is for the US to pay. And the US eventually paid. So even if hindi po nag-recognize yung losing party with the decision or with the award, so long as the outcome has been achieved through processes in the international relations, then okay na po yun. That can be considered as enforcement. So thank you, Mr. Chair.
Thank you. Ambassador Asuke, did you raise your hand? Parang I saw you raise your hand.
Yes, Your Honor. Thank you
Go
very
ahead.
much.
Go ahead.
Thank you very much, Senator, for reacting to the discussions. I have been listening very intently, Mr. Senator, to the discussions on the sovereign rights of the Philippines in its maritime zones and the territorial issues related to this. Mr. Senator, I think when we start discussing this bill in its detail, we have to be careful in discussing this because we cannot use UNCLOS to address territorial claims in the KIG, West Philippine Sea, or the South China Sea, or Scarborough Shoal. we cannot buttress the use of UNCLOS because the preamble of UNCLOS states that matters not regulated by the convention continue to be governed by the rules and principles of general international law. Now, what are these principles? Well, you have discovery, occupation, treaty pertaining to purchases of islands such as Alaska. So thus, UNCLOS only defines the maritime zones and the exercise of sovereign rights over these waters. And that's why we fully support the passage into law of the Maritime Zones Act, because it incorporates all of those issues in UNCLOS regarding the exercise of sovereign rights. I'm really supportive of the bill because it, for one point, Mr. Senator, it incorporates, at least in the version of Senate President Soto and Senator Revilla, it incorporates the entire decision of the Philippines versus China arbitral award. It is an expression that we are supportive of this decision, and it encapsulates our position on international law regarding the exercise of sovereignty or sovereign rights, I'm sorry, over the maritime zones. Now, if we have these zones and declare officially the exclusive economic zone, continental shelf, and the other zones, we put in motion the relevant provisions of UNCLOS in relation to the exclusive economic zone in Article 23, I think, which pertains to that the coastal state has the right to establish islands and conduct marine scientific research. More especially, Mr. Senator, we need to define the extent of our continental shelf in our waters, because it will put in motion the provision of Article 77 regarding continental shelf, where you have the reed bank and the other low tide elevations within the exclusive economic zone and continental shelf. Specifically, Article 77 states that coastal states exercises over the continental shelf sovereign rights for the purpose of exploring and exploiting the natural resources. These rights referred to are exclusive in the sense that if the coastal state, in this case the Philippines, does not exercise or explore the continental shelf or exploit its natural resources, no one may undertake these activities without the express consent of the coastal state. So if we put into law the Maritime Zones Act and incorporate UNCLOS as well as the decision in the Philippines versus China arbitral award, we are putting in motion the law into our national legislation and empower our enforcement agencies to say, hey, we have our laws respected. Now, Mr. Chair, regarding enforcement, well, this is a sovereignty issue. Enforcement of our regulations in these areas. But we are discussing how to enforce it. Well, I have maintained that this problem, our dispute in the South China Sea, as well as in the West Philippine Sea, can only be resolved by diplomatic negotiations. We can strengthen the position of our negotiators if we have an alliance, as we can see in the Ukraine dispute with Russia, where the United States and the European Union have supported Ukraine in order to ensure a peaceful settlement of disputes, and where there are no exchange of military action in that. So we cannot change China's behavior in the South China Sea or the West Philippine Sea, neither of being a good party. China has a grand strategic objective in the South China Sea. We have to understand its political algorithm and narrative. Diplomacy will enable us to challenge China in its position, its challenge, its narrative. And so if we have this legislation incorporating the entire decision of the arbitral award, we are empowering and giving our diplomats the necessary tool to sit down with other claimants in the South China Sea and resolve this issue by peaceful means. Diplomacy is talking with a basis in law. And so I suggest we have to be very careful in looking into this. We confine ourselves only on the sovereign rights, be careful that we do not raise the issue of territorial claims, because this is a matter that has to be addressed in another aspect of general international law. Thank you.
Thank you,
Mr. Chair.
Ambassador. Yes, I could see
Mr. Chair, Comsec
Justice
Su.
Carpio
Yes, sir. He is
raising
raising
his hand
hand.
digitally. Justice
Opo.
Carpio, you are recognized, sir. Comsec, do you hear or see Justice Carpio? Ako, I cannot. I do not.
We cannot hear him, sir, but we already unmuted him. Siguro.
Can you call Justice Carpio?
Yes, sir. We are trying to get in touch with him.
Anybody else who wants to join in the discussion?
Sir, Coast Guard, Chair.
Commodore
Coast
Dalangin,
Guard,
sir,
Coast
was
Guard.
raising his.
Commodore, go ahead.
Yes, sir. Maraming pong salamat, Mr. Chair. At while waiting for Justice Carpio po, in response to the statement earlier by Professor Manlawi, kay Atty. Batongbacal, and even Ambassador Encomienda on peaceful use of the sea, clarification of maritime zone, and enforcement. Kami po sa Philippine Coast Guard, we are promoting peaceful use of the sea, and even Westcom, kami po ang ginagamit para maipakita natin sa mundo that we are demilitarizing the area. Coast Guard and BFAR vessels po ang ginagamit sa enforcement sa pagpapatrol para po hindi tayo ma-accuse ng militarization. And the Coast Guard, we are as the primary agency mandated to perform maritime safety, marine environmental protection, and maritime law enforcement. We play a significant role in advancing our interest in the West Philippine Sea. At very important po, again, very important po na maklarify ito. Kasi kami po ang nasa ground. Gaya po ng mga discussion kanina, mayroon po kasing iba't ibang applicable na batas na mayroong laws na applicable only on territorial sea, pero hindi sa exclusive economic zone. So kaya po dapat maliwanag po yan sa amin bilang law enforcer na nasa ground talaga. And may take this opportunity to thank Senator Lacson, because tomorrow may hearing din po kami. He's leading the transformation, the organizational reform of the Philippine Coast Guard bill po. Maraming pong salamat.
Thank you. Anybody else?
Sir, so far wala po kaming nakikitang mag-raise ng hand.
Si Justice Carpio, hindi maka-online? Hindi maganda.
We are
Yung connection.
naka-online siya, sir, eh.
Yung
Naka-online.
connection. Senator Lacson, anything else?
I'd like to ask the DFA, ilan na po bang diplomatic protests and notes verbals ang na-file na natin in regard to the West Philippine Sea issue?
DFA?
Since the arbitral ruling was handed down. Anybody from the DFA?
DFA, who will answer?
Mr. Chair, Your Honor, since 2016, the department has filed to date 241 protests with the Chinese side, responding to 152. Under Secretary Locsin, we have filed about 226 protests. In 2021, 183 protests have been filed, and this includes the daily protest that we file with regard to the presence of Chinese vessels in the Philippine Maritime Zones, such as Pag-asa Islands and Julian Felipe Reef, among others. Thank you, Mr.
Note
Chair.
verbal.
Apo.
Ilang note verbal na i-file natin ang naipadala?
Sir, Your Honor, 241 na po na notes verbal since 2016.
And ano yung nakuha natin? Ano napala natin? Any positive outcome?
Well, it is part of political and legal warfare, so to speak. But of course,
We have also received the response from the Chinese side. They are reiterating their position, but the filing of diplomatic protests has significance politically and legally.
How?
Perhaps in the future, we may consider future actions, and then we cannot be accused of stopping. So that's why, sir, we continue to express our protests to their incursions in our territory, our sovereignty and sovereign rights. We need to be a persistent objector.
Okay. So in other words, ito yung for future reference. Yun lang na-achieve natin. In so many words, for future reference.
Well,
Not immediate positive outcome, but at least we look forward to something positive in the future. Maybe not in the near future, but in the future, baka diyan natin makita yung positive outcome ng mga pinafile nating diplomatic protests. Is that correct?
We need to be a persistent objector, Your Honor, and we cannot also be seen as acquiescing to what China is doing. So in that way, there's political and legal significance to the protests.
So no matter what, we will not get tired of filing diplomatic protests if need be.
Yes, sir.
Thank you.
Yes, Your Honor.
Now, I'd like to address this to any of the resource persons in attendance, Mr. Chairman. You know, I've always maintained to take the position of maintaining a balance of power, involving the more militarily capable countries like the European Union, Australia, United States, to name a few, who have reasons to pursue their own national interest over the West Philippine Sea area. What are your thoughts on this? When I say balance of power, kasi we cannot do it alone. Accepted na natin yan. We're so militarily degraded na hindi natin kaya talaga mag-confront. Not to provoke a third world war, but at least to maintain a balance of power in the West Philippine Sea. Para naman hindi parang too arbitrary yung action ng China na parang kanila talaga lahat yung area, especially within the 12 nautical mile distance from our coastline. So what are your thoughts on this? Anybody can answer, can respond?
Sige. See, I could see Ambassador Asuke raising his hand, and then Professor J and State Counsel Ganchun, you're also raising your hand for this question. Sige. Okay, so tatlo kayo. Okay, Ambassador Asuke, go ahead.
Thank you very much, Senator Pimentel and Senator Lacson. If Justice Carpio comes into line, I'm ready to give way for his comment. First of all, Senator Lacson, regarding the balance of power, maybe it should be more termed as an alliance with like-minded states, because in the balance of power and in alliances, we are going to subsume the national interests of the Philippines and a common interest of the alliance. And therefore, we have to define how that alliance will develop in order to promote our national interests as well as the common interests of those in the alliance. Initially, I would think that in the alliance of like-minded states, those who adhere to the rule of law, as well as to the decisions in the Philippines versus China arbitral award, the issue for maritime nations is really freedom of navigation in the South China Sea. The United States has been very clear, and as well as the European Union, that they have no part or they have nothing to do with the territorial disputes or the interpretation or the application of the. It is for the maritime states to exercise freedom of navigation to the South China Sea. Freedom of navigation is an essential component in the maritime doctrine of the U.S. Naval Academy because they are able to cover the entire world closing the South China Sea will be an existential threat to the maritime doctrine of the United States. Now, on the if I may add to the comment of our DFA colleague, Ms. Fisher, yes, it is important that we continue to file diplomatic protests. Perhaps the DFA could include the number of protests signed and sent by the Philippines to China starting from 1995, when China set up what it called just a fisherman's shelter. And all of these diplomatic protests were incorporated in the decision of the arbitral award. We need to continue the diplomatic protests. As Ms. Fisher said, we have to be a persistent objector in order not to put in place what is called an erga omnes, or where actions become customary international law because no one objects to it. We have to continue doing that. Now, as to its effect, the most important effect on that, Mr. Senator, is really to counter China, that they have no right in the West Philippine Sea. This is very clear in the arbitral award when the tribunal said that China cannot overlap any of its maritime zones in the Philippines because its EEZ cannot extend up to that area if they measure from their baselines in the south in Chinese mainland. So this law is really very important because it strengthens our negotiating position. We cannot approach China on a bilateral basis, Mr. Senator, because bilateral discussions with China will only raise the objections of other states who also have a claim in the South China Sea or in the West Philippine Sea. Again, the issue of sovereignty claim must be resolved by another tool in international law. UNCLOS clearly defines the sovereign rights of the Philippines in the EEZ continental shelf. Thank you.
Thank you, Ambassador. Senator Lacson. Yeah.
Before the next speaker, I premise that that question on the basic assumption that any foreign policy should be anchored on national interest. And how can we call upon the other states kung wala naman silang pinopose yung national interest over the West Philippine Sea area? So that is the premise of my question. That's the reason why I have always taken, as I said earlier, the position of maintaining a balance of power, because I know that other countries have their own national interest to pursue, at least in the area of freedom of navigation, as Ambassador Azuke mentioned. So yun lang po yung aking premise kung bakit tinatanong ko yung thoughts nila about the maintenance of or about maintaining a balance of power in the West Philippine Sea area. Thank you.
Sige, Professor J, and then si Assistant Secretary Fernandez or si State Counsel Ganchun. After Professor J. Professor J, go ahead.
Thank you, Mr. Chair. I agree as well with the comments already made by Ambassador Azuke. On the issue of the protest, if I may add, there is also one additional benefit in the department's numerous protests. And actually, the benefit is that it actually neutralizes some of the more careless and reckless statements made by other government officials on this issue, because it is really the formal written protest that officially expresses the real position, the real legal and political position of the country, and not some careless statements made at midnight press conferences. Second, with respect to the balance of power, yes, I agree that as a small country, we have very little choice but to engage in that kind of a game, shall we say. And the thing is, in the South China Sea, what really established, or what would have really established a balance of power in that area is the legal framework of UNCLOS, because what it does is to ensure that a certain portion of the oceans remains a commons, something that all nations have access to. And access is what enables us to reach these contested positions, like these isolated islands. And that's why it's important for us to stick to the system under UNCLOS, because that allows us, that practically guarantees us our ability to access these isolated areas. So in a way, this is how the interests of other countries and the international community also complements our own specific individual interest. If you can imagine a series of concentric circles where our individual interest is at the center, no, and that is the assertion and exercise of sovereignty over these islands that are now being contested. Around it are various mechanisms, various forces, which include the exercise by all states of their rights in the common area, which includes access. So that is how it is complemented, no? And that's why it is very important for us to make sure that this remains in place. Otherwise, if we were to agree that China basically owns the entire South China Sea, we ourselves are denying our ability to access these far-off places. So that is the legal foundation that supports our efforts to engage in the more practical or hard power aspects of maintaining this balance of power, which is through these alliances and strategic partnerships that we've been cultivating with many nations. I guess the only problem we have is that, well, unfortunately, different administrations have different ideas of how that balance looks like, or if they're even aware that there should be a balance. That is a problem. No? So it hopefully, again, if we were to at least agree on maintaining the foundation, then implicitly they will be more or less guided towards a more consistent policy across different administrations. Thank you, Your Honor.
Your Honor.
Thank you. Si State Counsel, is she still present? Wala na. Sino yun?
Justice Carpio.
Justice Carpio
Oh,
is online na.
yes, sir. Yes,
Can we give way to Justice Carpio? Ladies and gentlemen, sige. Justice Carpio.
Thank you, Mr. Chair. Thank you for inviting me. I'm sorry about the technical difficulties. I have a few comments on Senate Bill 2459 on right of innocent passage. I agree with Section 1, but I suggest that we add a reciprocity, because China requires our warships, if they pass through their territorial sea, they require warships to give prior notice. But when they pass through our territorial sea on innocent passage, they do not give us prior notice. So we should say here that if a coastal state subjects Philippine ships to restrictions when they pass through the territorial sea on innocent passage, then they will be subjected to the same restrictions when they pass through Philippine territorial sea on innocent passage. Because every time Chinese warships pass through the Balabac Strait, they do not notify us. But they require us to notify them when we pass through their territorial sea. Also, on scope and limitations of innocent passage, we should include a provision in Section 11.2 that the failure to switch on the automatic identification system, or AIS, is not in accordance with innocent passage. Because every time the Chinese warships pass through Balabac Strait, they turn off their AIS, and we cannot monitor them. Also, on sea lanes and traffic separation schemes under Section 14, it says here that in the designation of sea lanes, the Philippines shall take into account IMO recommendation. We should not be obligated, because we are a sovereign state. We should not be obligated to accept IMO recommendations. So it should state the Philippines may take into account. And we should delete 3B, which says we shall take into account any channels customarily used for international navigation. We don't want to use the Surigao Strait as a passage, as an archipelagic passage, because that will divide the country into two. We should allow archipelagic passage in the Pasig Channel and in the Balabac Strait, but not in the middle of the Philippine archipelago, where they can cross, divide our archipelago. So That's the reason why we have to designate archipelagic sea lanes, because we don't want them to use the traditional sea lanes that are being used right now in the absence of designated archipelagic sea lanes. Also, under Section 18, it should cover also archipelagic waters and not only territorial sea. Norms applicable to warships and other government ships. It should cover both archipelagic waters and territorial sea. And on Section 20, it says the Philippines shall designate sea lanes. Well, we should authorize already the president here to designate sea lanes. Otherwise, we will have to pass another law. It should be the president that shall designate sea lanes, and so that this law will be complete. Also, it says here that the sea lanes and traffic separation schemes under this section shall conform to generally accepted international regulations. We recognize customary international law. We do not recognize generally accepted international regulations. So we have to delete this because we don't want to be bound by so-called generally accepted international regulations. They are not customary law. This is the problem of Indonesia with IMO. So we should delete section 24, paragraph 4. And the last subsection of section 20, it says here, before designating or substituting sea lanes or prescribing or substituting traffic separation schemes, the Philippines shall first refer the proposals to IMO. We should just consult. The President of the Philippines shall consult with the IMO. We are not bound to follow IMO suggestions. We are a sovereign state. So we will consult with them, but to put here in the law that we are bound by IMO regulations would not be good for our country. Also in section 22, it says here the duties of ships that pass through our archipelagic sea lanes. We must include here that they have to turn on their automatic identification system as part of innocent passage. They must always turn on their automatic identification system. And also, submarines, when they exercise archipelagic innocent passage in our territorial sea or archipelagic waters, they must surface. They must not travel underwater. They must surface because that is innocent passage. They must show themselves because the Americans don't want to surface, but they have to surface if they want to exercise innocent passage. Lastly, there's a provision here that needs maybe clarification on ROCs, section 53. Well, there's some confusion here. Article 121 of UNCLOS says an island is naturally formed land surrounded by water and above water at high tide. That applies to Pag-asa or even Ituaba. But there is a qualification if it is not capable of human habitation or economic life of its own, then it is not entitled to an EEZ. It is only entitled to a territorial sea. So instead of saying rocks within the following lines, the boundaries under the client group, we should say geologic features above water at high tide, because that would include the islands like Pag-asa, because it still falls under section 120, article 121. Definition of an island is naturally formed land surrounded with water and above water at high tide. It still falls under that. So just so it will not jar the mind of the public, we should say geologic features above water at high tide instead of calling it rocks. That is all, Your Honors. Thank you for inviting me to this hearing.
Thank you. Justice Carpio was commenting on Senate Bill number 2459. Thank you, Justice Carpio. So, can we go back now to the question of Senator Lacson and then the reaction of our resource persons? Sino ba ako? Where did I stop? I think si State Council Ganchun raised her hand, but if she's no longer online, yan ma'am. Okay ma'am. State Council, go ahead.
Thank you, Mr. Chair. This is just to put on record the DOJ support for the filing of diplomatic protests. And as what Deputy Assistant Secretary Fisher stated, there is a legal significance for the filing of diplomatic protests, and that is to put on record our objection to the illegal actions of China in the West Philippine Sea. Because, Mr. Chair, if you agreed with the illegal action, how can you later on legally complain about the action if you have agreed to it? So we need to protest each time China makes an illegal action there to preserve our rights in the West Philippine Sea. So that's with respect to the filing of diplomatic protests. And Mr. Chair, when I raised my hand, it was already on the question of balance of power when I want to say something about the diplomatic protest. But on the balance of power, Mr. Chair, there is no, of course, definition really of balance of power in the legal field, no? But in international relations, when you say balance of power, it refers to a situation of equilibrium, wherein when one state becomes too powerful, the other states would form alliances in order to prevent one state from becoming too powerful, so that that one state cannot just impose unilaterally its decision in that particular area. So kailangan po ng equilibrium or balance of power, and how states do that by entering into alliances, as mentioned by Ambassador Asuke. So I just would like to also say that this balance of power can be formed not just by alliances, but also if we have a rules-based order as stated by Professor Batongbacal. So we need to support also a rules-based order in the South China Sea, and that rules-based order would be anchored on UNCLOS. So it's in the interest of all states that that China would also respect and uphold UNCLOS, because that will also provide, contribute to the balance of power in the region, Mr. Chair. And as to our comments on SB 2459, we only received it this morning, so that's why I am not saying our comments on it yet, but preliminarily, because Justice Carpio stated his comments on it already, we note that it is not just a Maritime Zones bill, it's actually a law of the Sea Act of 2021. So it's very comprehensive. It would include navigational rights already and all the other activities that can be done in the West Philippine Sea, like the construction of artificial islands, marine scientific research, etc. So we will submit our written position paper, not just on the two bills that are being discussed today, but also on your bill, Mr. Chair, which can be good, no? So we can already put into a comprehensive law the regulation of all activities in the West Philippines. But for purposes of expediting a law, no, since we have already a Maritime Zones bill in Congress, it's easier to consolidate it with the bill that is already filed by the Senate President. But if we want a comprehensive bill, this the DOJ can also support that, Mr. Chair. Thank you, Mr. Chair.
But can the senior state counsel Ganchun, can some of the subject matter included in 2459 be the subject of a subsequent law, assuming that we pass we pass the Maritime Zones Bill 2289. Pwede yun? Pwede silang two separate laws. The subject
Yes,
matter of 2459 can be divided into two separate laws. A Maritime Zones law and then a law of the sea law.
Yes, yes, it can be, no? Because as mentioned also by Professor Batongbacal before, the archipelagic baseline law and the maritime zones law are foundational laws. And from these laws, you can submit subsequent laws, no, that can also tackle other activities in the West Philippine Sea, like your navigational rights or passage rights, the conduct of marine scientific research, the construction of artificial islands, etc. So you can actually, or what are the other rights and obligations of states in the West Philippine Sea? So pwede po na,
Separable. Okay, good. That's
yes.
good. Thank you for that input. Yeah.
Thank you,
Okay,
Mr. Chair.
thank you. So let's hear from Deputy Assistant Secretary Fernandez of the DFA.
Yes, thank you, Senator Pimentel. I just want to express how absolutely I agree with the opinion of Senator Lacson that there's a need to establish a balance of power in the South China Sea. Considering how militarily and economically weak we are, in quotation marks, vis-a-vis China, it is really important to align ourselves with more powerful countries who are militarily more powerful than us. That way, we achieve a balance in the equation of power between China and the Philippines. But having said that, I'd like to add, Senator, that there are actually two kinds of power. One is hard power, which is based on military might and which is enforced through coercion. And an example of that would be an alliance through the MDT. But there's also the other kind of power, which is soft power, which is based on the good opinion of other countries about us, for example. And its main tool is persuasion. And I'd like to say, Senator, that the DFA has been working very hard to enhance our power in this aspect, our soft power. And proof of that, Senator, is the increasing number of countries that are now expressing their support for the arbitral award. Like-minded countries who uphold the rule of law, who value the rule of law, are now expressing in a nuanced but increasingly vocal way their support for the award. And for me, that is as powerful as the hard power of alliances. The fact that you have on your side the opinion of an increasing number of countries actually increases your power and equalizes the equilibrium between China and the Philippines in terms of the South China Sea issue. On a third point, Senator, I'd like to add to what my colleague, Deputy Assistant Secretary Fisher, said about the utility of the protests that we've been filing against China. It is true that as Senator Lacson said, it is in a sense something for future use. It's a record that we file to register our consistent objection to the activities of China, as well as to record our position, our maintaining position about the South China Sea issue. But there's also a present utility to the protest, Mr. Senator. Can you imagine if we do not make such protests? Can you imagine what else China would be doing in the South China Sea if we don't, as it were, put a spotlight on what it is doing and alert the global community about what China is doing in violation of the rule of law in the South China Sea? So for me, the notes of protest have a present utility. They are actually like a spotlight which we focus on China every time it does something wrong. And it prevents China from further doing anything illegal in the South China Sea in violation of the rule of law of UNCLOS and the arbitral award. Thank you, Senator Pimentel.
Thank you for that input, sir. Professor Manlawi, you're raising your hand.
Thank you very much, Your Honor. I would like to reaffirm the strategic importance of filing diplomatic protest because that will strengthen our documentary evidences of our claim. So if we decide to pursue a legal claim in the future, then we have strong documentary evidences to support us. And at the same time, its current significance also is compelling China to also exercise self-restraint, like what we experienced in the UNCLOS, that we went there again and accomplished our resupply mission. And also, diplomatic protest is a sign that we regard the problem as a diplomatic issue that can be resolved diplomatically. So it's very important that we continue to do that. But what we have experienced in November, on November 16, Your Honor, that diplomatic protest is not enough to deter China from its current activities. So we need to really increase our patrols in the area in order to guard our interests there, because of the cardinal principle in international politics, Your Honor, that if we cannot patrol our maritime zones, we cannot own our maritime zone. So it's really very important that we really have to increase our patrol activities there, not only to prevent sovereign states to incur in our territory, but also to have effective capability to respond to rising threats in the area, like illegal, unreported, and unregulated fishing activities and other forms of transnational crimes, which are in fact threatening the survival of the marine ecosystem of the West Philippine Sea. Thank you very much, Your Honor.
Thank you. Ambassador Suke, you're raising your hand.
Yes, Your Honor. Thank you very much for giving me this opportunity. Regarding your comment, Mr. Senator, on the splitting the bill into two provisions, I support the move to have two bills. One is the Maritime Zones Act, and the other is on the UNCLOS Implementation Act. We need the Maritime Zones law as the foundational basis for negotiations that we will undertake. The issue on the West Philippine Sea is a foreign relations issue. If we establish the fact that we have a maritime zones legislated in national law, as well as following rules of international law, you're saying to the whole world and empowering our diplomats that we are compliant with our obligations. So we need the foundational basis for negotiations. And then we can go later on to define how these foundational law will be implemented on specific terms like sovereign rights, fisheries, marine scientific research, exploration of resources in the continental shelf, such as the Reed Bank, also Calayan Island Group. At the same time, on another point, Mr. Senator, regarding the issue on the IMO, I agree with Justice Carpio that the IMO resolutions are only recommendatory and that the Philippines would only have to take note of these resolutions. Resolutions are not mandatory in itself, and therefore, in the redrafting of the bill, we have to temper the language there so that we can reinforce the sovereignty of the Philippines over implementing decisions that affect our maritime zones. However, Mr. Senator, if the IMO converts itself into a diplomatic conference and adopt conventions that will be binding upon all states after the diplomatic conventions, then we have to be bound by it. In the case of the Safety of Life at Sea Convention, the MARPOL Convention, the International Oil Pollution Compensation Fund, these are treaties of which initiated by IMO, discussed in the diplomatic conference and adopted by states and therefore binding upon the Philippines. Those are the things that we have to take into account when we implement treaties arising from the International Maritime Organization. On the point of the archipelagic sea lanes, I agree with Justice Carpio that we have to be careful of how to designate this because it is a long process, Mr. Chairman. The designation of archipelagic sea lanes is covered by a resolution of the IMO regarding consultation with states. They have to concur or they have to give their comments on these archipelagic sea lanes, as in the case of Indonesia, because it involves the exercise of navigation to the archipelagic waters by all states. So I suggest that maybe the archipelagic sea lanes should be put down later on because it's a very difficult and complicated issue that must be conducted with thorough research. Finally, Mr. Chair, I think we should also address in the future the exploitation of resources in the Philippine rice. The Philippines has sovereignty and sovereign rights over the resources in the Philippine rice, especially the polymetallic nodules, which are essential components or rare earth in the manufacture of electronic devices today. So there are many challenges that Congress will face, but I think it's important that I support your suggestion that we pass with urgency the Maritime Zones Act in order to establish the foundational basis for which we will defend our sovereign rights over these maritime zones and empower our negotiators to move forward on this issue. Thank you.
Thank you, Ambassador. Anybody else? Comsec, what's the status of the archipelagic sea lanes bill? Have we heard it?
Yes, sir. We're done with the committee report, sir. We just need to file it.
Okay. Thank you. Thank you. Thank you very much. I think in that bill, we designated 3. Tama ba?
Yes.
Do I remember
Yes, sir.
correctly?
Initially,
3?
sir.
For
Yes,
the
sir.
information of Ambassador Asuke, please take one more look, sir, at that particular bill because we're about to file it.
We
We'll
will
give you
send
a
it to the
copy.
ambassador, sir.
Yes, Ambassador. Go ahead, Ambassador.
Thank you very much for reacting on the archipelagic sea lanes. I agree with the comment of Justice Carpio that we have to give the president that prerogative to determine the archipelagic sea lanes because the president will have to be properly advised on how the archipelagic sea lane should be designated. Maritime powers will have to look into that application because the main purpose of an archipelagic sea lanes, Mr. Senator, is really not for commercial ships because they can sail anywhere, especially if it's in a port call. The archipelagic sea lanes is intended really for military vessels in order to make an expeditious crossing from, let's say, the Pacific Ocean to the South China Sea. And the president should be given that prerogative to determine it because the president implements how to protect the regulations on how to defend the sovereignty of the Philippines. So therefore, I suggest that we look at that issue later on because it needs a lot of studies, mainly because archipelagic sea lanes, Mr. Senator, being for military purpose, other states will have to look the depth of the archipelagic sea lanes because their submarines can navigate there underwater. Aircraft carriers can navigate over the archipelagic sea lanes in normal mode as well as in submarines. Normal modes for archipelagic sea lanes means for aircraft carriers, they can launch ships or aircrafts, fighter jets aboard a ship whenever it's an archipelagic because it's the normal mode. And therefore, we have to determine how far they can fly, observing the distance from the coast. So this is a very complicated issue. We have to be very careful, Mr. Senator, because maritime nations, especially the maritime powers, will be looking at how we do this. Because if we do not comply with all of these provisions in the UNCLOS, then we will be facing a lot of protests from maritime nations saying that we are not compliant. And we do not want that to happen. Maybe we should take a more hard look and careful look on the issue of the archipelagic sea lanes. Thank you.
Thank you, Mr. Ambassador. Anything else from my fellow senators? Okay, so siguro ganito po ang gagawin natin since we informed the resource persons late about the addition to the agenda of the 2 measures which we just anticipated would be referred to the committee but not yet officially referred to us. I will set another hearing if it's okay with the Senate President and the Senator Lacson's so that Senator Lacson's proposed Senate Resolution number 954 can also be discussed more extensively. Since we already have a hearing set on Friday on the statelessness treaty, maybe we can add this to the agenda and then we will invite all the resource persons present today again to the hearing on Friday, 1:30. We'll start at 1:30 plus the persons named by Senator Lacson, yung Westcom. Yes, Senator Lacson, yes.
Yes, sir. If I may, can we hold it on Monday instead of Friday, this coming Friday?
Instead of this Friday, Monday. But okay, I will continue.
Yes,
I will
sir.
continue.
Yes.
For the record,
I second the request.
may bicameral conference pala ako. The chair would not be available on Monday, sir. I have a bicameral conference committee.
On Tuesday.
14, sandali, December 14. Yeah, sige. Okay, Tuesday. So, ganun na lang. So it would be a continuation of this hearing with the four measures in the agenda. Okay. So, if we can start again at 10 o'clock, is 10 o'clock okay? 10 o'clock on Tuesday, we will continue with the hearing on the same four measures. Okay. No, but Senator Tolentino requested that we take a look at the SB
2288, sir.
2288 on the baselines law because the Maritime Zones bill might affect or vice versa the baselines law. So the committee secretary will add to the agenda for Tuesday all measures concerning baselines so that our experts, resource persons can discuss whether these two subject matters are connected. That when we change one, do we also take a look at the other at the baselines? We will decide that. We will talk about that on Tuesday. So it will be more than four, ComSec, more than four measures. Okay.
Yes, sir.
Okay, but we will continue with the hearing on Friday on the statelessness treaty. Is that the correct name of the treaty?
Yes, sir. It's the 1961 Convention on the Reduction of Statelessness.
Okay, yan po. We will continue with that on Friday and then on Tuesday. So, okay, so December 14 na 10 o'clock tayo. Okay, so okay na sir. We will suspend. Okay, so thank you very much to all our resource persons. Thank you for my fellow senators for keeping me company and for actively participating. Our staff, thank you also to you, stenographers, EDP staff, secretariat, and thank you to the public, to the Filipino people who are watching us in YouTube and Facebook Live. So they're very interested in the topic. So salamat po all of my fellow government officials, our professors. See you again on Tuesday. We need not repeat what we have stated today. As we just supplement what we stated today. Okay, so any others? Wala na po? Kung wala na, okay, we can have time for deeper study of the measures. So in the meantime, the chair declares our hearing suspended. Maraming salamat po.